Welcome. This video presents the third section from an article titled Doctors Specializing in the Law of Medicine and Board Certification in Legal Medicine. The text is compiled by Dr. Sandy Sandbar. The video is prepared by Tyler James Sandbar, and narration is by AI. Physicians and other healthcare professionals can specialize in medical law and ethics through a combination of 1. Advanced education, 2. Specialized training programs, and 3. Professional development opportunities. This approach ensures a comprehensive understanding of both the medical and legal aspects of medical practice. What are the steps that physicians take to specialize in medical law? 1. Foundational medical education. One must complete pre-medical requirements, which is usually a bachelor's degree. Some medical schools require as little as 2 years of college or offer a combined program to obtain a bachelor's degree and a medical degree in a total of 6 years or less. But one must attend medical school for 4 years. Then the physician completes a residency program, which can last from 3 to 7 years, depending on the specialty. 2. There is also additional legal education. One can obtain a Juris Doctor (JD) degree from an accredited law school. Few individuals become attorneys before starting medical school. However, the majority obtain an MD or DO degree first. Some universities offer dual MD and JD degree programs to integrate the study of medicine and law. Instead of a JD, some physicians elect to complete specialized courses in health law and medical ethics. 3. Physicians can enroll in fellowship programs, focusing on medical law and ethics. These programs provide specialized training and often result in certification as a medical legal consultant. 4. There are continuing medical education, CME, specifically designed for physicians interested in the legal aspects of medicine. The topics that are covered include medical malpractice, healthcare regulations, and patient rights. 5. There are postgraduate training programs in medical law and ethics. 6. There are workshops, seminars, and conferences focusing on the intersection of medicine and law, for example, the Academy of Ethics and Legal Medicine and others. 7. Physicians can join professional medical legal organizations such as the American College of Legal Medicine, American Academy of Legal Medicine, American Health Lawyers Association, AHLA, and American Society of Law, Medicine, and Ethics, ASLME. 8. Traditional apprenticeship-like models are not common. Mentorship programs can provide similar benefits. 9. Some training programs include clinical experience in legal settings, such as working with legal teams on medical malpractice cases or advising on healthcare regulations. 10. There are fellowship programs that offer specialized training in various fields, including medical law and ethics. These programs typically last 1 to 3 years and involve both theoretical and practical training. 11. Some medical residency training programs incorporate elements of medical law and ethics into their curricula. Residents can also pursue CME courses and workshops that focus on medical law and ethics. 12. Finally, physicians can pursue a combination of fellowship and residency training to specialize in medical law, but not practice as lawyers. What are the practice options for physicians with a medical law specialization? The physician may elect to practice independently. In the case of private practice, the physician who is specialized in medical law may offer legal consultations, expert witness services, and medical legal advisory services. They may provide expert opinions on medical legal cases, healthcare regulations, and compliance issues. They may become employed by hospitals, pharmaceutical companies, medical device manufacturers, life insurance companies, health insurers, or law firms. Government employment is also available in federal agencies such as the FDA, CMS, ARQ, DoD, VA, state and local health agencies, and congressional staffs. Some physicians choose academia and teach in law schools, medical schools, or administration. Others, medical specialists, elect a hybrid practice by combining their independent practice with part-time employment or consultancy roles. The factors that influence the medical law specialist's choice include 1. Career goals, with preference for autonomy or structured work environments. 2. Market demand is another factor. What is the demand for medical legal expertise in the local market? 3. Regulatory environment. Is there regulatory support for private practice or employment? Thus, the non-lawyer physician with a specialization in medical law has the flexibility to practice independently, be employed, or adopt a hybrid approach. What is considered as the practice of law in the U.S.? Each state defines the authorized practice of law somewhat differently. The common activities that typically constitute the practice of law include giving legal advice or counsel to others regarding their legal rights or responsibilities, representing clients in court or in legal proceedings, drafting, preparing, or filing legal documents or pleadings for another person, negotiating legal rights or responsibilities on behalf of another person. Unauthorized practice of law (UPL) occurs when someone who is not licensed to practice law in a particular jurisdiction engages in activities that are considered the practice of law. This is illegal. It can result in penalties such as fines, injunctions, and even criminal charges. The governing law pertaining to the practice of law varies by state. Every state has its own rules and regulations which are enforced by state bar associations or similar regulatory body. These rules outline what constitutes the practice of law and the requirements for becoming licensed to practice law in that state. What about a specialist physician with education in medical law who is not a licensed attorney? Well, this specialist physician cannot provide legal advice or represent clients in legal matters, as this would constitute the unauthorized practice of law. The specialist physicians can serve as consultants for attorneys working on medical legal cases. They can contribute valuable expertise in the medical aspects of a case. In this role, as a consultant, the physician can provide expert opinions, medical insights, and factual information relevant to the case. The key is that the physician must not give legal advice or engage in activities that would be considered the practice of law. What are the consequences of practicing law without a license in the U.S.? One, unauthorized practice of law is a criminal offense in many states. Violators may face misdemeanor or felony charges, depending on the severity and circumstances. Penalties can include fines, imprisonment, or both. 2. Individuals may be subject to civil penalties, including fines and injunctions to prevent further unauthorized practice. 3. Individuals caught practicing law without a license may suffer reputational harm, which can affect their professional and personal lives. 4. They may be held financially liable for any harm caused by their unauthorized practice, including malpractice claims. 5. Courts may issue injunctions to stop individuals from continuing to practice law without a license. What are the differences between state and federal laws governing law practice? Every state in the U.S. has its own rules and regulations governing the practice of law. They are enforced by state bar associations or similar regulatory bodies. State laws also specify the penalties for unauthorized practice of law. Certain areas of law are governed by federal regulations, and attorneys practicing in these areas may be subject to federal licensing requirements. For example, patent law and immigration law have specific federal licensing requirements. Multi-jurisdictional practice is addressed by the American Bar Association ABA Model Rule of Professional Conduct 5.5. It provides guidelines for attorneys practicing in multiple states or before federal agencies. However, individual states may adopt variations of this rule. A specialist physician with education in medical law who is not a licensed attorney can serve as a consultant for an attorney working on a medical legal case. They can provide expert opinions, medical insights, and factual information relevant to the case. However, they must refrain from giving legal advice, representing clients in legal matters, or engaging in activities that would be considered the practice of law. By adhering to these guidelines, the physician can contribute valuable expertise without violating unauthorized practice of law regulations. State bar associations take unauthorized practice of law very seriously. 1. Upon receiving complaints or discovering potential UPL, state bar associations will conduct a thorough investigation. This may include interviewing witnesses, reviewing documents, and gathering evidence. 2. If the investigation confirms UPL, the State Bar Association may issue a cease and desist order to stop all activities related to the practice of law immediately. 3. State bar associations often refer UPL cases to law enforcement or the State Attorney General's office. UPL can be a criminal offense. 4. In addition to criminal referrals, state bar associations may also initiate civil actions against individuals engaged in UP and pursue financial penalties. 5. Some state bar associations publish notices or warnings to inform the public about individuals who have been found to engage in UPL. 6. They may collaborate with other regulatory bodies, such as consumer protection agencies, to address and prevent UPL. Teaching medical law by a specialist physician who is not a licensed attorney is generally not considered the unauthorized practice of law, UPL. The reasons are as follows. 1. Teaching legal subjects, including medical law, in an academic or educational setting is not considered practicing law. Educational activities are distinct from providing legal advice or representation. 2. As long as the teaching involves explaining legal principles, theories, or case studies without offering legal advice to specific individuals or entities, it does not constitute UPL. 3. A specialist physician with education in medical law can share their knowledge and expertise in an academic setting, contributing to the education of others without crossing into the realm of practicing law. It is crucial for the specialist physician to ensure that their role remains purely educational. By maintaining a clear distinction between teaching and legal practice, the specialist physician can avoid any issues related to UPL while effectively contributing to the field of medical law education. What are the consequences for a non-attorney medical specialist who teaches law without a license? 1. Institutions may have specific requirements for credentials or expertise, but a law license is usually not mandatory for teaching. 2. Institutions may have specific credential requirements for instructors. A degree in law or related field might be required by the educational institution. 3. If the teaching role involves providing legal advice or otherwise practicing law, it could lead to scrutiny or disciplinary actions by academic institutions or professional organizations. Non-compliance with these policies could result in employment or contractual issues. 4. Misrepresenting qualifications or engaging in activities beyond teaching could harm professional reputation and result in employment consequences. 5. While teaching law without a license is generally permissible, certain jurisdictions may have stricter rules. 6. Regulatory bodies or professional organizations may scrutinize the activities to ensure that the teaching does not cross into providing legal advice or representation, which would be considered UPL. 7. If the teaching extends beyond an academic setting and into a commercial enterprise without proper accreditation or oversight, it could face issues related to false advertising, consumer protection laws, or misrepresentation. 8. Falsely claiming to be a licensed attorney or misrepresenting qualifications could lead to fraud charges. 9. And if the teaching activities mislead consumers or students about the nature or value of the education provided, there could be violations of consumer protection laws.